initiate chaos theory guarantees that we'll play like lightning shots, sounding like thunder. For every time in the face that it hits us, we're faster. Well, they should know by now. They see the world keeps trying to shake us. It only wakes us. The pendulum swings. The pendulum swings. It's in a beautiful darkness. Only another. It's full steam ahead. Full steam ahead. All about the Betty Express. Misdirected from the start. It's a runaway train. Come a freight train. I come a freight train. In a beautiful darkness, the Petty Express. In a beautiful darkness.
I really don't either. I'm actually shocked that there is a jury question, but that's where we're going to start out today. It does look like they are looking at video. Now, the state was the one who made a big deal about one of the headlights being out. So it does seem like they are really focusing on the headline or the headlights or the taillights, sorry.
Go on the record. All right, we're back on the record. The state of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. We have the attorneys here. We have the defendant here. We have the alternates in the courtroom and the foreman. I was handed a note, which has now been marked CJ for court with jury exhibit number 1. The note reads, and I just want to go over it with you. It says, all of the videos of car, and then it says back of the car, rear right. What I need more clarification as to exactly what you want. So here's what I'm going to ask you to do. Okay. If you want to tell me, you can. If you know, fine. If you don't know, I don't want you to guess. You can go back in. You can just rewrite this so it's a little bit more clear of exactly what you want. And then I'll bring all the jurors out and we'll tee it up for you and so that we can play it. We just weren't exactly sure. Sure. Okay. So I'll bring it. Let me get this back to you. You just let me know and then we'll come back. So, okay. Well, I'll wait for you. Take your time.
I'm glad that the judge is clarifying. I think I understand what he's asking or what the jury is asking for, but again, making sure that he understands completely. And as much as we joke that we want this to be 15 minutes, it is a man's life. And unlike Paul, most everyone else does have morals, does have, that part of them that hesitates and makes them want to make sure this is the right decision. So I am kind of glad that I'm actually very glad that they're asking questions, especially since
knock on the door again.
Since the state, again, in their closing, made a big deal and said, that was part of what drew us to Paul's Porsche. His loaner Porsche was the fact that, it had the same kind of, or same tail light out.
Thank you.
And he didn't say it in a condescending way. He didn't say, you didn't. I think some judges can be a bit snobby. And I think, again, it might be irritating to have to explain something that's kind of like the ABCs of your own job. But it's not every day for a jury. Okay, y'all, is it just me? And look, I think I would love to have hair long enough to make a bun, but I swear this thing has grown by 3 or 4 inches every day, and she's just waiting for someone to notice, or it's just me. But I swear to you, like, when we started this trial, it was at or around parallel with the frame, and now it has grown to be at or around parallel with the other side of the frame. Yes, sorry, JKD Buck. They are basically, they sort of asked a very oddly phrased question, but what I think they want to see is all of the video of the Porsche Macan from the rear part, because the state made it very clear that they were able to identify, the car for the same thing, or as the same car because of this broken rear tail light. I just can't do another case that's going to be decided about a tail light in New England. I I'm triggered. I'm so triggered, y'all. Oh, for the love of Cheetos, figure out how to write a question. Another reason.
Have sent out a second note when we asked for clarification. The note reads, side camera, 30 Green Grove Road, Porsche Macan returning from Colts Neck, right rear bumper light. They then send out S 264, which shows that the Macan, and then in both, it shows the Macan at the lower part of the screen, and then on the top part of the screen, it shows the surveillance. And then they send out 263 D.1, which is the surveillance that shows the back of a vehicle with the box around it. So I'm going to ask the state to tee up that video.
Mr. Murray, a chance to read it over one more time. Just for the record, it appears they're talking about 308 Green Grove.
Yeah, that's what I read.
It says 30 Green Grove.
It does say that.
It says 30 on it.
Okay, just for the record, there's 308 Green Grove, and then there's 32. But it appears what they're talking about is the car making a left onto Tilton Drive.
This one says 308 Green Road,
Right, that's the
and this,
That's the driveway from that's the two cameras. This is one camera from 308 Green Grove, and this is the other camera from 308 Green Grove.
Do we all agree it's 308 Green Grove? I'll confirm with the foreman that that's what they want.
I think so, both angles from 308 Green Grove. Right, I think that's probably
We're all in agreement? Okay.
And we're talking about returning.
You know, I'm sitting here looking at it, I'm like, I wonder where he gets his robe, because the ones you buy on Amazon are kinda they don't look as swishy. I like the swishiness of his robe and the fact that it's probably not 100% polyester. Uh, so, yeah, I love that I'm shopping for more comfy looking robes for when I play a judge and for pretend.
Like 408 timeframe.
Can we bring the foreman back out, please? Foreman, please. Promise I'm not trying to be difficult. So the note says side camera 30 Green Grove Road. There's a 308 Green Grove Road, and then there's a 30 Tilton. So we believe, based on the photos, you know,
Want to use that as a reference.
of 264. So this is 308 Green Grove Road.
Yes, those are the ones we like to see.
Okay.
That
And-
page and the second page.
Okay, and do you want to see, so that we're clear, on S264, did you want to see the vehicle driving out and driving back, or just driving back?
Just going back.
Okay,
This one, just this,
okay,
and this.
and that. So these are the videos that you want to see. And when you say this, it's 264, it's the second page. You pointed at the top where it says November 20th, 2018, 408 and 28 seconds.
This one.
Okay, and then the other one you pointed to is S263D1, which says November 20th, 2018, 207:55.
Correct.
All right, so that would be the one that's leaving.
Correct.
All right, so just the time frame of the back of the vehicle that you want to see. All right, we're going to tee that up. We'll bring you back out in a minute. We'll bring everybody out together. You can just let everyone know. Okay? Thank you, sir. I want the two of you to look at it also to confirm what they're doing. I want you to be comfortable with exactly what's going to go on the screen. But Mr. Decker, I just want that area of time that they're asking for, the back of the vehicle. So it's probably not more than 5-7 seconds or whatever it is. It's not the entire video that they're asking for. They're asking for the back of the vehicle.
Well, no, holy water. What in the early 90s Ally McBeal is going on here? We have a camel skirt and burgundy
This is a CJ.
leggings? What in the name of Blossom? How much do you think an average household with a couple of cats would need to fill a super soaker? Because I feel like that involves math. Yeah, I'm so confused why you would have the light color break, because it draws your eyes. So I'm guessing she likes to cover up her midsection. She's not too comfortable with it, but it draws your eyes to exactly your midsection and where the color changes. So if you don't like that part of you, why would you draw your eyes to it? This is why I don't get fashion. Oh my God. Yes. Only Amy's smart. She's like the bizarro world Amy. Ooh, prepping. I don't know. I do know that you shouldn't try to drink it because it's perfumed. I was not a normal child, but I wanted to be a saint. I didn't realize it was like acts of faith, not drinking holy water. I thought it was more of like a Teenage Mutant Ninja Turtles thing, not so much a like actual acts of goodness thing. Made sense to my 9-year-old brain.
But they have not fixed.
Okay, so we just don't have live stream right now, so it is what it is.
I am.
Need is for some reason.
I'm ready.
Can we ask the jury to come out, please?
Bye, folks. You're gonna come right and sit down. Yeah, just keep the grapes in here, please.
You're gonna go back to your regular seats.
Regular seats?
Yes, please.
I don't know if it's just me and maybe I'm in a kinder mood, but this is the first time that Paul has read, like whipped little schoolboy. Before, it's always been, it never looked quite right. It's almost like he's learned how to act. But I think he's realizing that, yeah, this is more of a cursory dotting our I's, uh, all that thing.
Okay?
That will be.
Take a second. Tell me when you're ready. Everybody be seated. Turn over to you, okay?
Yeah, I'll be fine.
I just want to make, because I want you to focus. So you're good to just, okay.
I'm
So
perfect. Thank you.
You're welcome. So for the record purposes, I had the foreman come out because I just wanted to clarify. CJ1 indicated all the videos of the car, back of the car, rear right. I had asked, and that came out at 8:50 a.m. I asked for clarification from the foreman. The foreman then went back in, he came back out, gave me a second note at 9:21 that says side camera 30 Green Grove Road, which is 308 Green Grove Road. It's 30 Tilton and then 308 Green Grove Road. It was clarified to me that you wanted 308 Green Grove Road. And then it says Porsche Macan returning from Colts Neck, right rear bumper light. And then I was supplied with S263D.1, which is the vehicle, a vehicle leaving on November 20th, 2018 at 2:07:55 a.m. And then I was also given S264, the second page of that exhibit, which shows a vehicle returning on November 20th, 2018 at 4:08:28. So what I'm going to do is I'm going to play just that video surveillance from 308. It's about 15, 18 seconds going one way and then about the same amount of time coming back. So that's what I'm playing for you. That's what the foreman indicated. If for some reason I don't answer your question the way you needed it to be answered, all you have to do is tell me and I will fix it for you. Okay?
Thank you.
All right. With that being said,
Will you approach for 1 second, Judge? I'm sorry.
all right.
Oh, and Paula, thank you for the gift box. My husband got it, and I am saving it for today because all the boys needed to be encouraged to actually put their names on Valentine's. The terror, the horror, the humanity. So I told them that they had a surprise if they did all their chores, and I figured they'd already be, candied out. So thank you so very much. They are gonna love them.
I'm sorry. Let me just make sure, just hear me out. The original note says all the videos of car, back of the car, rear right. And then it says side camera, 30 Green Grove Road, Porsche Macan, returning from Colts Neck, right rear bumper light. Now, when I was talking to you, when I showed you 263D1, that's that time frame, 11/20/2018, 2:07 and 55 seconds AM. That's the car not returning. That's the car leaving, a car leaving. And then the 11/20/2018, which is S264 at 4:08 and 28 seconds, is it coming back? Do you want?
I think Beach Girl, what they're making sure of is to not give them too much. So it has to be very, very specific what they want. So the judge is trying to see if the jury wants just the back angle of these to, look at the taillights, or if they're wanting all of the videos. And that's what he thought he had communicated to the foreperson. Now, what the foreperson probably thought is, okay, we're going to get the car videos. So it's more, do you want all the car videos, or do you only want the parts of the car videos that show the taillights, because you are very specific about the taillights. So it's just a communication. And I like that the judge is being very specific and asking all of the jurors, because making sure that, the foreperson doesn't kind of overtalk, or they get the information the first time. So I do like this, because I think that had Judge Bev just been a little better, I think the jury wouldn't have felt so shamed about asking questions, because it's kind of really crappy what we do to juries. We say, okay, we send you back here to make this really important, decision. Send us a question. And then if they don't write it in perfect legalese, they can't answer it. Yeah, so basically that's what they're trying to figure.
Coming back and leaving? Did you want both? Or did you only want the one of the car coming back, returning at 4 o'clock? If you don't know the answer yourself, I'm going to put you back into the jury room to confirm that, because it was my understanding when I first asked you, I asked you about both times, and I thought you meant that you wanted 2:07:55, the car leaving, because that's the picture you're showing me, and then 4:08:28 of the vehicle coming back. So I thought you wanted one going out, one coming back, but these angles that you wanted. So I may be wrong. Do you need a minute to talk to everybody? Yeah. All right. Alternates stay out here. Everybody else go back in the room. Just tell me what it is. I apologize. Here, sir, I'm going to give you your note back. Can be seated.
Fancy. For the love of Lemmy, human communication shouldn't be that hard. This is why I don't work well with groups. Like, why is simple information so hard to communicate to a group of people? I can't see him. I can see him having a very bad attitude. I can see him thinking that he's still hot poo. I say we burn them with holy water. I don't think even Goodwill should have them. Like a Viking tribute, only in a dumpster, because Paul doesn't have honor.
It's 9:42 p.m. It says, showing vehicle going and returning from video 263 D1. Please freeze so we can running lights. That's the way it reads. I'll show it to you. 2, returning vehicle from 263. M.1.
Kim K, for the love of God, just wear your glasses. Look, it does no good to have contacts if you are constantly looking like your eyeballs are trying to jump out of your face. So, again, you can look very cute with some glasses, but if the contacts suck that much, don't wear them. Probably. Ponytail was defense. So it's set up in a weird way. The first tables, side by side, in the front are defense, and then the state is behind them. It's really an odd setup because then you have the defendant so very close to the witness stand. Okay, why did the state prosecutor murder a couch to get that suit? Looks like she murdered an Afghan. Like a blanket, not a dog or a person.
So it's this one here. That's what they're trying to depict here.
It's coming back. So that doesn't seem to be, but I guess they're still looking for the driveway. Because that's referenced in previous notes.
I know, but we're not, they don't know.
You know, I like a suit that that would be both a suit and really good on a recliner? Because I can imagine that would be a comfy recliner,
Giving them what they're
and it
asking.
would hide stains unless they
Give
were
them all the
red.
more, we'll give it to them.
Sure, we'll do these two.
Going and returning. Going and returning on 263 D1. So going out, coming back on this camera angle.
That's why I said Siobhan trapped herself an outfit. She was like, these curtains will be upcycled.
So it's both times for the front.
I do not know. I'm just glad she decided to curl the back part of her hair,
Look at it and then
because for the entire trial she has gotten, so I will demonstrate because it's only bobby pins and I can put it back up really easy. But for the entirety of the trial, this woman has meticulously curled her hair, but now this might just be the noticing things that bother me, but this little bit right about here, what I tend to call the undercoat, or in other cultures might be considered the kitchen, she just refuses to continue to curl it. So it's been dead ass straight, and she's got big old, like country music hair everywhere else. So it's confused me. Yes, they would like to see the car that Paul drove, the McCann, at very specific times to look at either the taillights, I think. Uh, because the state did make a big deal and it did explain that, in order to ID the car, they looked at the missing taillight on it, and I think there was a black paint stripe or something. So I think they're wanting to see very specific times where in the video we capture the car either without that headlight or that tail light or not. I think so.
once you're done, Mr. Murray and Ms. Massalone, you can just give it back to me.
Okay. I just wanted to see the clips that they pulled up.
Of course you can. Of course you can. You can leave it there for that. Go ahead. Let them see it. Just let them see it.
The only time you see that, it's like right here.
Try to back it up right
Yeah.
right there. We'll have all the lights off.
Now, I can't remember if it was out or simply the cover plasticky thing was off. Howdy, howdy. No, they haven't. This is a jury question. They're back on verdict watch again.
Yeah,
They're
of course.
trying to get to the exact moment the jury wants to watch.
No, I think we're in agreement with the clips.
Okay, so we're all in agreement. We have them both teed up. See?
One at a time, but yes. Yep.
Yeah. Sorry. Knock on the door.
Turn out, folks.
9:42, I received the third note. Sorry, just want to make sure we have it right of exactly what you're asking for. This is and we marked it as CJ3. It says showing vehicle going and returning from video 263 D1. Please freeze so we can see the running lights. And then the second one is returning vehicle from 263 M1.1. So you can see that same. And you gave me a copy of 263 M.1. So we see that. We're going to show that. And we're also going to show 263 D.1. And we're going to stop it so that you'll be able to see it. So we'll do that now. If we could turn off all of the lights, please. Okay, you can unfreeze it.
Can you freeze it there?
Go back a little bit. I just heard the jurors say that they wanted it paused again, so go back a little bit more. Back a little bit more. Tell us when to stop. Stop.
Right there. There, and then one more after that.
Like a second after.
A little bit further. Further there. There.
Okay, that was the area going out. Everyone good with going out?
Yeah.
Now we're going to do the return.
Y'all, can I be real honest with you? I don't know. I hope the jury saw whatever it is that they needed to see. I was looking for a tail light, so I basically all that is to say I have no idea what we saw. But if the jury thinks they saw what they saw, then God bless.
Pause. Do we have everything you need?
I do.
Yes.
Okay. All right, ladies and gentlemen, you can go back and you can continue your deliberations. We can turn the lights back on, please. Yeah. And we can give them back these exhibits also. I'm just going to keep the note. Could you ask them to give us the other two notes back so that I have them secured, please? Thank you. Okay, our alternates, you can go back to your location, please. Thank you so much.
Oh, I would bring all the coloring books. So here is where we are currently. And we will start the judge roasting the heck out of the defense. And then we will switch over to the sentencing in the au pair Banfield case. I don't know why I want to say Banfield. Oh wait, is it live? Oh, it's just a wait screen. I was like, oh, sidetrack. Yeah, I guess of all the evidence that I would want to re-see, that would not be the case. That makes sense. Now, Justice is a Process is a great channel. They do clean up and make shorter streams out of trials, so give them some love. Now, I will say, I was kind of shocked because I try to go to a lot of different sites to see how people are perceiving the trial. And I will say that on Justice is a Process, there were a lot more people, and again, it wasn't the majority, but there were a lot of people that thought that the judge overstepped and gave a possibility for an appeal with the way he acted with the attorney. I don't think so. I think she was being deliberately deceptive by omission, and he, like every parent, got a little tired of asking the same question and her dancing, more than Bill Clinton and what does the word "is" mean? So, yeah.
Yes. Question. Now, prior to the last day or two, when was the last time you looked at that text message? Answer. The day I sent it, November 20th, 2018. Question. So you haven't looked at the message since? Answer. No. Question. When you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question. Or excuse me, answer. It's an iMessage and it changed from delivered to read. Question. Okay. So do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer. No, I didn't look at it for 7 years. Question. Now the fact that it said read, did that stand?
And that's where it really confuses me because I could look, I'm willing to buy crazy theories as long as they have evidence. What I will not buy is that Katie's father is in jail. You could tell she's very, very protective of his father, very, very, she's a daddy's girl. She very much loves her father. And you're telling me that she knew about evidence that in her mind led more to the guilt of another person, and she let her dad stay in prison for 7 years as she sat on it? It just doesn't make any idea.
Stand out to you? Answer. Yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Paul Caneiro. You mentioned.
Now, what I will give the defense here, because I do like to call balls and strikes, is that she was trying to be clever here, but the problem is that there are rules for a reason. Thank you. Mo, I like the phrase you used a few days ago. It sounds good on the surface, but when you logic it out, yeah, well, okay, because I would say things and not understand why people would get upset. I use the example of being about 13 and I can never get my shirts clean. Being 13 and my, younger cousin trying on dresses and not realizing that when she asked me if, this dress made her chest area look nice, I wasn't supposed to say, "I'm sure when it grows in, it'll be nice." So I have to logic things out sometimes because I don't get those when are we supposed to tell the truth, when are we supposed to lie kind of things. Like, when are we supposed to use that whole, white lie thing when we're not supposed to? So that's kind of how I've had to kind of learn the social niceties.
Earlier, Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was...
Now, if you haven't been watching the trial, the defense, this will be in the defense's case in chief, and they brought on first Paul's older daughter, Katie, and she was pregnant and she did look, I understand what they attempted to use her for, but her personality was more snarky and, oh, what is it? Veruca Salt rather than, someone you can root for. She was like, I want the world. I want the whole world. I want to lock it right up in my pocket. It's my bar of chocolate. I mean, honestly, I thought that the squirrels were going to come in or the geese were going to come in and she was going to be labeled a bad egg. So basically, what the defense is trying to do here is that if she has knowledge of electronic files, she is supposed to give that to the state. Now, if she just has like verbal knowledge of things, then, she can kind of skirt the line. But basically, what she tried to do was, oh, if I don't ask for those files, I don't have to turn them over to the state, but I can still bring it up. Yeah. The fact that I can remember the words to that song and again cannot remember my password for Amazon to the point that I'm pretty sure I've got the two-part verification down pat. I'm just pissed off. Look, between you, me, and Amazon, look, I don't remember passwords anymore. So why don't you let me cycle between the three that I kind of remember and we just leave it at that. Again, why I'm bad at this. I'm constantly the one that has to mark to say, yes, this is my device. I am just stupid. So if you could just let me recycle passwords. Come on now. Just a bit irritated about that.
When you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this. I've reviewed the state's brief, which I received somewhere around 8 o'clock last night. It was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone, to include the actual text message that was marked red and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the state, which it never was. And because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response. And the defense's response, for the first time, defense counsel admits that she had an actual screenshot of the phone. Or
Ma'am, for the love of God and fear of chiropractors, sit up straight. You want to look powerful? You know what doesn't mix? Having, freaking Brett Favre shoulders and then looking like am I too turtly for the Turtle Club? I mean, what is this? Do you want to have a hump when you're 27 or I don't know, 33? I'm bad at ages. I really am. Because I know that I'm not supposed. Look, y'all, would you stop asking people who are not good at people reading? Well, guess my age. Look, I don't know if I'm supposed to be accurate or lie to you. So you need to tell me because I can't read your face and I don't know. And I don't want to be. I didn't ask to be in this this freaking quiz show. I'm not a carny. Yeah.
phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a.
Nope, Squid. The only thing I have learned right off the bat that I absolutely know how to answer is, or never ask is, unless I see a baby crowning, I don't assume no one is pregnant. Look, unless there is a baby that has done dropped out of you, I don't assume anymore. I live in the Midwest. It is a 50-50 thing here. So, I'm just saying, that's about the only social nicety I have learned down pat.
Discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence about that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble. But of course, this was dealing with when Vogt collected the DNA samples in 2020, not in 2018. Second, the state argues that it demonstrates that this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out,
Okay. I forgot it takes a while. We are gonna get to where Kim K tries to explain stuff because this is where
You decide not to turn over because you weren't going to use. It doesn't mean that it's not a discovery violation.
do, do, do.
Without the document, I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
Good, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Because
Oh no,
worry
we
about-
need to baconate because speaking of wearing couch covers, what in the poncho via from Kittles is this poncho on Dex or Trinity from Dexter? Gonna remove the what in the name of City Slickers and Pottery Barn am I looking at here? Nothing about this makes any sense.
Because I worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know. There's no time is going to allow me to figure out how that became read. It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Walls would disagree with me, that time is going to do anything at this point in time. It's not going to allow me. I know I can find out when.
Damn it. No. You know what song I have stuck in my head? Boy George. And Do You Really Want to Hurt Me? It takes time. Something. I don't know because I always switch the song because I didn't like it.
Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message.
Also, y'all, we are 19 days into this, and I have not one damn clue what Milton has been doing here. I think basically he threatened to torch down the courthouse unless they let him sit at a table and pretend to be a lawyer. Well, Squid, I'm actually so on a tangent because we're kind of waiting for the other hearing to start. But I have finally broken down because I was so trying not to spend any more money. I finally broken down, and Mr. Mo reminded me that getting a like big table on wheels to kind of put over my bed doesn't mean that I always have to stay in bed. So, like on days that my legs are feeling good, I can still use my craft station over on the desk. But for days that I'm not feeling the greatest, I can always, have that, sliding table. So I've been fighting it because I'm what we like to call a stubborn ass, and cheap. Stubborn ass and cheap.
After the fact, it's just that document is just clearly inadmissible.
But on the plus side, with the bed, we can do a lot. I can do a lot more and do streaming from over there on uncomfy days. So on days that I just want to have like random streams, it'll already be set up. No, not yet. So it has been an odyssey because first we were waiting for the new desk. So I have a desk that was supposed to be a vanity. Then we got the laptop, and then we got my phone, and then I got the wrong cord thing. So it's just been an odyssey of hurry up and wait. But we're getting closer. We are double checking and double measuring the correct bed table thing and the cat tree. So we have 2 missions this weekend between Sunday shenanigans and do. Oh, something or oh, his homework. I was like, I know someone had to do something, but it wasn't me. His homework.
The court ultimately tells the jury to disregard the testimony about it. That would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Massalone, would you agree with me that the document, the screenshot that you had, was an electronically stored document within?
Now, Squid, I want you to listen to her responses and try not to imagine baby Squid giving you the exact same responses when she has done something wrong, like, eaten a cookie when you can obviously see chocolate all over her face, or maybe got into your real expensive lipstick, and it's all over. And they're like, why you ask if I touch your makeup?
Katie's phone.
The document that I had, Judge, was simply a screenshot of what she observed in live time.
So, but my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discussion.
I'm asking you a question, yes or no.
I'm only laughing because this is when Mr. Mo comes in. Do you want to explain what all these packages are? Well, I believe they originated in China, and then they took a long ride on an airplane to get to us. He's like, they have your name on them. And then they went to the post office and they took a ride with our post lady. What are they? Well, see, I don't quite remember. But this is exactly like trying to ask your kid something they are obviously guilty of. And she's like, well, I mean, if you want to be technical about it, yes, it might have been electronical, but I didn't have the phone. Duh.
The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes. Is it electronically stored? As far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before. So you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say I had a fleeting moment to really think about it, but I didn't think it would be fair to surprise this.
I don't think this woman's ever had a thought that doesn't kind of slowly turn on like a dimmer switch. I call bullshit on her having a fleeting thought. I feel like it's more of a slowly jogging thought. Fleeting is just too quick. I'll give that she has like slow jog thoughts.
State with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So yeah, you did have time. You absolutely had time to turn it over. And it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that that witness took the stand. So the state, at least at that moment, could have had the opportunity to say,
We were rewatching where the judge is ripping the defense a new one after she tries some discovery shenanigans. So then I figured we would go with the defense's case, which has been hysterical. Now we are not going to watch the expert, but all of the friends and family member, the cavalcade of weirdos who possibly need to be on a list, because y'all, the defense thought these people made them look good, thought they made Paul look good. And in between that, starting in about 24 minutes, we are going to be watching. Now, I do feel a little odd about watching it, but the au pair in the Benfield case is going to be sentenced today. So we'll watch sentencing. I'm sure there are going to probably be some victim impact statements. So do be mindful of that. Now, honestly, I don't foresee them going longer than 5 p.m. today. So if they don't have a verdict by 5, I think they'll go home and come back Tuesday. I don't foresee that happening. I don't think anyone in the jury is going to be so stalwart in their convictions that they are their weekend of having no ability to talk about anything that they've witnessed. So there you go. That's kind of what we're doing today. I don't get it. I thought the wife was very attractive, so I couldn't quite get the look, the au pair does nothing for me. I know I'm not her target audience and she's not mine, so maybe it's a dude thing, but wow, dudes, yikes. Do better. Like if you're gonna cheat with Carmen Electra. Like that makes sense to me. I mean early aughts Carmen Electra.
hold on for a minute. We want to do some research on this before it comes out on the stand. Tier says one thing. It does. But Tier does not mention, and it does not deal with the fact when something, it's not created by you. No one's asking you to create anything in this case. It already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This, in this court's opinion, aligns more.
So basically, so you don't have to understand, Tier basically does point out that if the defense has something. Basically, we saw it used in the Karen Reed case when the experts would write a very scant report. If they had to write a report at all, it would be very scant, very short, to not give the state a whole lot of an idea of where they might be going in their testimony, more just a CV. And that strategic use of the rules, what this woman was trying to do is, oh, well, I know that there is in fact a digital record somewhere, but I'm not going to ask for it. And then if I don't ask for it and I don't have to, then I don't have to turn it over to the state. Now, those two things do not mean the same thing. One is to protect work product from the defense attorneys. So, say the defense attorneys are writing down notes of what an expert's saying. Well, the state doesn't have access to those notes, even if they were written, with the expert in mind. They can't have that. So, she is trying. If she were clever, there was a way to do this more cleverly. Again, we've seen it in the Karen Reed case, but she's not clever.
Or with State versus Knight, that is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it and you didn't turn it over. So if your answer is anything other than, when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it?
Now, why is it that this defense attorney, toddlers and drunk people, 90% of my future reaction channel is definitely going to, revolve around this principle. But why is it that toddlers, women like this, and then drunk people, when given an easy option, like, I'm sorry, sweetheart, I know you're heartbroken that the red cup is in the dishwasher, but we have the blue one and it's just the same. So would you like to have juice in the blue cup? No, I'm just going to hold my breath until the red one is done. All right. Well, when you wake up from, passing out, you can still have the blue cup. This woman is going to pick the hard road, and then none of us are getting Frosties tonight. Dad was going to take us to Wendy's, and this heifer had to piss them all off.
Or is it not electronically stored information?
Judge, I frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something.
This is the closest we've ever come to hearing my truth in a courtroom from a lawyer. So my truth, when you look at the statute, is that the defense is basically able to do whatever because we're not the government. I'm pretty sure that's exactly what this says.
At trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I
do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the.
I love that again, now remember, this is him just saying in a louder, more authoritative voice everything she did in fact do. Now her response is going to floor you if you are a child of if you were a latchkey child, you would not have survived. You tried to talk to your parent like this, the way she's going to get ready to talk to him. We would still be in the ICU.
Physical screenshot in advance, so the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what.
So you didn't authenticate evidence that you were going to bring in a quadruple murder trial because you thought, YOLO, let's wing it. I'm a Virgo. Okay, so Falanos, I'm torn because I did wonder if she has a twitch, or some seizure disorders can look like, a twitch or kind of an eye tick. So I didn't want to assume that, maybe what I was seeing as a petulant child reacting when they can't have the last word wasn't, just that. But I also think that she isn't very good with contact wearing. I think she's attempting to wear contacts because she's a little vain.
I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody.
All right. We are actually switching out to sentencing. Now, I will be very honest with you guys. I haven't caught this case, but it does kind of go with our whole reverse speed trial. So we are going to be watching, I guess, the sentencing of the au pair first. And then we will be watching the sentencing of Brendan. But I don't think his is until April or something. So we'll watch this sentencing. We might do a Saturday stream. So like Nick and Dave did the Jodi Arias case, we might do, 2 or 3 hours every Saturday. And we are just going to be covering the states kind of cross what they bring out. And it's going to be a little odd. We're going to start at closings and then go backwards and see if by the time we get to opening, the case has proved their case, or the state has proved their case. I've just heard that the defense in this particular case was also a lemon. So I can't do stupid defense. I can't. Yeah, Mustang, that's why I do try to go, because you guys, I'm going to be real. I have very little patience for willfully stupid people or people that I would assume would be intelligent. And they're not. I have very low tolerance for that, so I know about myself I can be very judgmental, so that's also why I was trying to look at other sites, how they were perceiving the case, because I'll be the first one to tell you that, I try to be open to other possibilities, but when you've proven yourself a butthead, I no longer give you any credit other than the credit I feel like I'm obligated to logically and, to give you if you make a point. So, there were a lot of people, and I think when we get to her response to his dress down, I think the people that feel like the judge was mean are people that have never been yelled at by a boss. That's what I've heard. That's what I've heard, Kimmy, Kimmy. It's kind of actually, it it is very much the reason I kind of like being behind sometimes, because we can speed through things, and especially if I know ahead of time from creators I trust like Baker and other things. I have been asked to look at that, so we are gonna look at it. Um, again, all honesty, I really don't know anything more than, cursory information about it. So, I did wanna kinda go in with fresh eyes. I know Nick's been covering it, and, just about everyone's been covering it. It probably hinders my channel growth greatly, but if everyone's covering a trial, I try to find something else because it bores me. I I know it does. I know it because I could still be on, Sarah Boone's stuff and things like that. Also, yeah, I could be relevant. But it just I figure there has to be in a giant world of the internet, there has to be at least 5 or 6 people that maybe wanna watch something else. And not that there's anything wrong with really, really liking the Karen Reed stuff because I think there's still a lot rotten in Canton, you know, but, and it's not that I Oh, awesome. Yes, that would be great. Yeah, because I was trying to figure out something, but yeah, Saturday is probably when we will be doing the reverse through or speed run through of the Banfield case so we can watch the Faust case because the Corey Richins case is in theory supposed to be coming at the end of February. Oh, I mean, at the end of February, and that is going to be awesome. I always feel like such a poser, you guys, when I get to these big trials and I know nothing about it. Everyone else, like Baker, has like his little notebook and he's like, he's like, that is from this hearing with this person, and these people were here. And I'm like, I'm pretty sure this case is about adults. And honestly, that's what's selling the Corey Richins case. Not that it's not a tragedy when any person uh, loses their life, b but I am glad that we are going into a case that doesn't involve any children. I don't know why I started this year with 2 of these, but I will say the Caneiro case, for as trying as it's been, I think it's been a very good example of a state. Um, it's nice to have another example of a very what could have been a very emotionally charged case handled so respectfully, so incredibly, you know, with restraint, with reserve, and just very, very mindfully also of the jury, the impact on the jury. Yeah, that's the other thing is I kind of like to do stuff, but sometimes I think I offer a fresh opinion because I haven't stayed up with the cases, so I come in basically like a juror. Yeah, and And that's where Mustang, it's being a little slow. And welcome, Kimmy Kimmy and Post Punk Mama. We are waiting for the sentencing in the Juliana Perez Magales. Wait, I didn't think there was an H in Spanish. Or is it a Y? It's been a long time since senior Spanish. I'm not going to lie to you. I know there are some letters that we have and they don't have. Yeah, I've got I will say it's the thank you, really a cat man. Couldn't remember. Pernilla, thank you so much. The StreamYard has been a butt monkey about staying staying up with the chats here lately. I don't know what it is. I mean, it's probably user error, to be very honest with you. Now, this one I didn't understand making it, and again, look, I'm not trying to help criminals, but y'all riddle me this. Why create this insanely complex Rube Goldberg, I'm gonna be the brave husband and come in with like Charles Bronson in my Webley. Why make all that up when antifreeze exists? I mean, Mr. Mo said you probably shouldn't say that just randomly in conversation. You sound a little serial, eat, eat. And I was like, no, honestly, why make a mess? You get fluids everywhere. Your house smells like cordite. You know, it seems to me it tastes good. I mean, again, like there was a time where you couldn't turn around because there was every other trial was a Visine trial. I'm just saying, as a child of the 90s, I remember every other trial was an antifreeze trial. You didn't have to go to like we'rethekinkypeople.com. I mean, it's fine that you did. I mean, not really, because you kind of mutilated your wife and another rando, but bucket lists are a thing, I guess. I always know when something's inappropriate to say when my mom looks at me and she's like, "You didn't say that out loud, did you?" And I look back at her with this blank stare and I'm like, "Yeah?" She so I always know that maybe I said something like socially unacceptable when my mom's like, "You didn't really say that out loud, did you?" And I was like, "Maybe not." And thank you, Tammy. I hope you have a wonderful, wonderful birthday, and hopefully we just get some rain. I know. Well, yeah. I mean, she's only covering one boob, as you do. I mean, although, would you say then that she's on shirts or skins? How does that divide? Is she, like, on both sides because, like, half shirts, half skins? I would be the only one that would be confused by that.
For cell phones, please place.
Oh, we have sound. Mr. Mo was like, "How often do you think, of these things?" And I was like, "Well, not often enough, uh, to not remember that if I actually searched all the things I think about on Google, I'd probably be on a list." And he's like, "That, again, is not as comforting as you think." And I said, "Honey, I would never actually attempt red rum because everyone gets caught. Also, I'd have to leave my room." A spear, and it looks like one of Baker's baguettes. My classic joke is they never look until you're on your 3rd husband or late husband. Mr. Mo is not a fan of that joke. I was like, my first 2 late husbands were. That's how they're gonna get me. Cash app, no taxes. Yeah, she does look like she's happy to see you, but she also has a boob out. Oh my god, is she current year? She's so current year. She's ready for June already. Brave and beautiful, ma'am. Yeah, I mean, it's not a pattern per se. Excuse me. Well, I thought we were getting ready. I don't like hurry up and waiting. See, this is how they get me. I call this court tease. It's not exactly like a C word tease, but it does give you law balls. Uh, so kind of like law blue balls. Again, the way I think about things. And thank you so much, Wolfram. Have a wonderful, wonderful lunch. And thank you for all of your Modly Mod duties.
Asperati presiding. Please be seated and come to order. Okay. Let me just, you want to do the quick matter on the Banfield case?
Judge, did you want to do that before or after?
Yeah, let's just do that right now. All right, because Mr. Carroll, I think, is here. Mr. Carroll, if you want to come forward, just on the case of Commonwealth versus Brendan Banfield, Mr. Banfield's presence has been waived. Mr. Carroll is present, Commonwealth is present. This comes on your Commonwealth's motion to seal 2 of the defense exhibits, correct?
Judge, yes, 2 exhibits, and we're actually going to, we're going to orally add 2 more. We have been approached by Mr. Phillips representing Innova
Why is Phil Donahue here?
Hospital and a member of the public about another case that includes, or I'm sorry, another exhibit that includes personal information. So the exhibits, the defense exhibits we would ask to seal are 120,
Right.
121,
Okay.
122, and 123.
Right, and that has protected patent information, is that correct?
Protected health information or protected personal information.
Okay. All right, okay, so I got you. All right, any objections?
No objection, Judge.
All right, we'll go ahead and seal those for, I assume there's many patient information in there, is that what it is?
There, yes.
Okay, so 120, 121, 122, and 123, correct?
Yes.
All right, I'll grant your motion. That's fine. Thank you, Mr. Carroll.
Thank you, Judge.
All right. All right, Commonwealth versus Magalhaes.
Yes, it's
Good
the
morning, Mr.
nanny.
Campbell. Thank you. All right, the case of Commonwealth of Virginia versus Juliana Perez Magalhaes. Ms. Perez Magalhaes is present in the courtroom with her attorney. The Commonwealth is present, comes today for sentencing. Are we ready to go forward today, Mr. Campbell?
Yes.
Okay, how did cousin It and Velma have a child? I mean, love is love. I just kind of genetically.
Your Honor.
All right, have you reviewed the pre-sentence investigation report with your client?
We did, Your Honor. No changes, additions, or corrections.
All right, does the Commonwealth have any?
No changes, additions, or corrections.
All right, I'll make the pre-sentence investigation report part of the record. The Commonwealth, as far as evidence, I do have, victim impact statements that I have already reviewed. Is there any objection to those victim impact statements?
Your Honor, my position, I talked to the Commonwealth, is that some of them fall outside of the definition under.
Okay, which
the code.
ones? Or are you objecting to certain ones, or are you not?
Your Honor, the specific ones are the ones that relate to Christine Banfield, so
Okay.
family members of Christine.
So you object to those with victim impact statements?
Yes, Your Honor.
Okay,
And Judge, what I would say to that is that certainly the statement of facts that we presented, and that is included in the pre-sentence report, includes information about also the murder of Christine Banfield. I understand that this charge itself reflects the killing and murder of Joseph Ryan. However, I do think that the voices of Christine Banfield's family are important in this hearing as well.
I understand, but he's only been charged with the murder. I mean, she's only been charged with the murder of Joseph Ryan. So the only victim impact statements the court can consider are the ones based on which the Commonwealth has charged her with. So I can only take into consideration the victim impact statements from Joseph Ryan's family.
Understood,
Okay,
Your Honor.
so I'll do that and I'll grant your motion. Okay? All right, do you have any other evidence?
Judge, I do, in light of the court's ruling, I'm going to have 2 witnesses to
Okay.
call. The first of which is going to be Deirdre Fisher.
Okay, Deirdre Fisher?
She is appearing via Teams.
All right, okay, ma'am, if you could just raise your right hand for me. Do you swear or affirm to tell the truth under penalty of law?
Yes.
Okay.
Good morning, Ms. Fisher.
Good morning.
Could you please state your name for the court?
My name is Deirdre Maureen Fisher.
And can you tell the court your relationship to Joe Ryan?
Joseph Ryan is my son.
And can you tell the court of any psychological injury that you have received resulting from this offense, or any changes to your personal welfare, lifestyle, or relationships resulting from this offense?
Is this outside of the statement that I
No, ma'am.
am going to read?
You go ahead and read your statement.
Oh, so I read it now?
Yes,
Is
ma'am.
that correct?
Yes, ma'am.
Okay. All right.
Now, I will say that I think Sean from Potentially Criminal did show a video, and she is an interesting woman. I absolutely. The clock is, let me see, should be, I'm keeping it going. It's still moving. It's at 3 hours, 26 minutes. I like her glasses. I've said it once and I'll say it again. What in the designing women Murphy Brown is going on with women's fashion? No, no, don't do it again. What is with these you guys realize that you're trying to make me wear a collar and I have to wear something around my neck? No, I said no. I said no to turtlenecks. I said no to Dickies, which are just half a turtleneck. You cannot make me.
Thank you, Honorable Judge Penny S. Escaretti, for giving me the opportunity to talk about the impact of the murder of my son, Joseph Nathan Ryan. My baby boy was born 2 days before Christmas, making that our special holiday. His middle name was Nathan, which means gift. Since Joe's murder, I haven't been able to take down my little Christmas tree, which sits behind the urn with his ashes. I say good morning to him each day when I turn on the tree's lights. But of course, that's not Joe sitting there. He can't say, I love you back. When Joe was taken from me cruelly and callously, murdered by Juliana and Brendan on February 24th, 2023, I lost so very much, more than I can possibly name. I lost my confidant, someone who knew me deeply, listened without judgment, offered advice with my best interests at heart.
Also, he could get some strange and not have to pay to divorce his wife. I just will never understand. I will never understand. If you don't love your wife, if you want to, you know, then that's a choice. And then you're going to have to deal with the financial consequences. They dragged this random person who was just, you know, doing his own thing, being honest about it at least. I just don't get it. I don't get any of it.
I lost my biggest ally and my cheerleader. That empathetic voice saying, "Mom, you got this. Mom, you should be kinder to yourself." I lost my rock and protector. The person who flew down repeatedly to take care of me when I had cancer. I lost the comfort of knowing that my son would be there to care for me when I'm an old woman with illness or dementia, just as he cared for his grandmother and grandfather. I lost my financial sustainability due to grief's torturous effect on my health, both physically and mentally, which has affected my ability to work and function. I lost my peace and sense of well-being. I can never unhear Joe's.
And I have not always told the story, but I've only heard it once in my entire life, but there is a sound that a parent makes when they, and in my case, it was a mother that found out that their child was gone, and it's a sound that you will never forget. And part of me is a little bit jealous that she can feel all of these emotions all at once and really honor her. Some people are very good at feeling all of the emotions, whereas mine kind of gets stuck. So part of me does envy that she can feel all of this without like a delay. Not that it makes it any easier. I'm not going to lie to you guys.
Moans and cries after he was shot, the cries of a dying man. I can never unsee the image of his lifeless, bloody hand from the trial images. I lost nearly all my friends who couldn't handle dealing with someone lost in grief or understand why my life can't just go on. I lost the chance to ever be called grandma. I will never have that. I lost the sound of Joe calling me the most beautiful word in the world, Mom. I lost my Christmas baby, Joseph Nathan, my greatest gift.
And I really like this because think about, and again, I only know the very bare facts, but this man has had his background, his honor, his proclivities, all dragged through the mud this entire case. You know, people have judged everything. Now, Falanos, from what I understand of the case, here is the kind of 5-minute story. The woman with the black hair was an au pair from Colombia, or was it Brazil? I can't remember. Brasilia. And she was working for an IRS agent and his wife and their child. Well, IRS agent husband decides to get with nanny because, well, she doesn't have kids and she's fun. And the wife is all naggy and shit, I guess. Well, they decide that, you know, divorce is hard and money and, you know, alimony and child support is like hard also. So, you know, they decided to concoct a plan where they were going to put the IRS agent's wife on a fetish site where she wanted consensually to have someone random from the internet break into her house to consensually play act a grape. Now, if you're into that and it's all the consensual, have at it, have fun. Don't tell me about it ever. I don't want to know. Uh, that will be my only exclusion to the don't ask, don't tell. But if I ask, tell me everything. Just say you don't want to know, Mo, and I will know that I will no longer, you know, on that path. Just, choop. But so basically, they put up the picture of the wife, the, you know, husband, and the au pair, and they lured this man over with the husband lying in wait. So the wife is at home, not realizing any of this is going on. She thinks she has the day off. She's doing some laundry or, you know, something. Well, you know, guy who thinks he's there for a little bit of fun creatively goes in there and she's really fighting back. So he thinks in his head that this is, I mean, we're assuming because he didn't survive, but you know, he must assume that she's really into role play. Now, she is fighting for her life because she's terrified and he thinks that it's a role play. Well, the husband barges in and uh uses a force multiplier on guy that was attacking. Guy that was attacking had not actually taken out the wife yet. So the husband decides to take the knife away from guy who was, you know, fake attacking and stab his wife with the knife. Now, girlfriend, being the Bonnie and Clyde ride or die that she was, noticed that attacker man was trying to leave. He was not quite all the dead. So she decided to double tap end him. So that is why she is going to get a sentence. But she did take a plea deal to flip or turn state's evidence in the husband's case. Yeah, it seems like a really interesting case, but when I saw that the defense was different and yeah, no, y'all's everyone deals with grief, not just loss of life different. Yeah, grief isn't something you just get over. No. No, your life grows around it is the way I perceive. It's the only way I can explain it. Because there are days where it's just a tiny pebble, and then there are days that it's a big old mountain. Uh, so, you know, it changes. I don't know.
The impact of Joe's loss doesn't go away. Will never go away, but only grow. So many tears, so many times reaching for the phone to call him, only to remember that he won't and can't pick up. So many times hearing the phone ring and wishing it was him calling me out of the blue about something happening in the world or in his life. So many empty Christmases and so many birthdays without him singing to me in his awful yet beautiful voice, tone deaf. So many moments of trying to remember the exact sound of his laughter and fearing that someday I won't. So many sleepless nights. So many nightmares of his brutal murder and fear, confusion, and of the pain he must have felt. So many screams and guttural cries into my pillow, feeling the loss of my son. So many moments of reading horrible things online, lies told about who Joe wasn't.
Yeah, and that's the thing. I mean, honest to goodness, I don't care what this man was into, but he was made a punchline. He was made, you know, a deviant, a punchline, and all these things. And I I I have to say, if it doesn't if it didn't bother either of them, now would I ever talk to my mom about smexy time stuff? Not in a bajillion, manillion years, like a septuple-tillion, no. But I don't have that kind of relationship with my mom, and if they did, that's okay, but there's been a lot of ugliness, towards especially this, and especially with the kind of, whatever you wanna call it, alternative lifestyle, kink, or whatever factor. It's made it much more salacious, and a lot of sites have really doubled down on the whatever you wanna say, the role playing, the subject of whatever the role playing was, and I'm very sorry, Janine, I'm so sorry.
So many moments defending and explaining who my son was and why he couldn't have committed the murder of Christine Banfield. God rest her soul. So many conversations with others, draining them and me of a chance to make happier memories together. So many stomach aches. So many doctor's appointments, hospital bills, feelings of shame about my health. So many times wishing I could tell Joe about another milestone in my weight loss journey, seeking better health. Knowing
I was gonna say, but I tend to notice things, and when I don't wanna deal with emotions, I was like, "You know what? She looks a lot slimmer from when she did the interview with, or f that I saw on, Potentially Criminal."
how encouraging and proud
I'm
he
so
would
sorry.
be. So many lost moments, so many moments of loss. My son's life was used and thrown away, seen as worthless and utterly disposable. Disposal by those who plotted and executed his brutal murder. Do I think or dare hope that there will be justice for Joe's death? For my loss as his mother? I don't believe that's possible. What I do hope is that, even for a moment, that the world and you, Judge, will say Joe meant more than nothing. that he was so
And I feel so badly because, again, as a mom, look, she remembers the moment they laid this little boy on her chest, and to have to deal with everyone on the internet with their hot takes. That's why I don't say anything about trials. And I'm a snarky asshole. I am a cynical asshole. But everything I put out, I try to think, okay, if a victim or like a mom was to come by, would it be something that I would feel okay saying to their face? If it is, then I'm okay saying it. If I go back and say, you know, I'll correct it. But so many people want to get on their high horse and want to celebrate things and want to, point out that they're better people because maybe, they're vanilla. Fine. I got your back. I forgot about victim impact statements, you guys. I'm sorry. I just knew that there was sentencing. And the fact that the people who did this to her child were using him as a pawn, they didn't even see him as a person. So he's been the butt of internet jokes, and he wasn't even seen as a person to the people that did this. It could have been anyone else's son. It's just so sad. Ooh. Oh, yeah, I saw that. I loved it. When I get back into boxing, I'm gonna use it.
unworthy of dignity and life, who didn't deserve to be used and thrown away, treated as utterly disposable. Thank you for listening and for weighing the trail of pain and loss Juliana left in the wake of her calculated, cold-blooded murder, with her life and future as her only concern. My son, Joseph Nathan Ryan, was not and is not disposable.
You fucking tell him, Mama Bear. Because that's honestly the other reason I didn't cover this trial. Look, I get it. It's not my jam, but at least he didn't make it his persa-fucking-ality. I mean, you know what? Give me someone who does something really kinky and I don't know because they didn't make it their own daggone personality, and I'm happy as a clam. I don't care what you're into or what you do. Just don't make it your personality. And then if someone, if you happen to find out something and it doesn't take away from any part of them being a good person, then let it go. Let it go. Let it go. Just mind your own and let it go.
Thank you for listening.
Thank you, Ms. Fisher. Please answer any questions that Mr. Campbell may have.
All right, cross-examination. No cross-examination. Okay, thank you, Ms. Fisher.
Thank you.
All right, your next witness.
Judge, the next witness that I have is going to be Ms. Sangeeta Ryan, who is present in court.
Okay, Ms. Ryan.
Do you swear or affirm to testify truthfully in this case under penalty of law? Thank you.
How did I thought Roy Orbison was dead. Also, I thought he was a man. What in the 5th grade gym teacher is this? I'm not saying she drives a Subaru to court, but I'm not saying that she doesn't drive a Subaru to court. Look, y'all, I don't do good with emotions.
Good morning.
Good morning.
Can you please state your name for the court?
Sangeeta Ryan.
And can you describe your relationship to Joe Ryan?
Is this where I read my statement? Who I met, Joey Nathan Ryan, was my nephew. And Honorable Judge Ascarati, thank you so much for the opportunity to speak today. Thank you for allowing the Ryan family to speak up for our Joey Nathan Ryan. We thank the jury for helping us achieve justice for Joe and Christine. And we thank the Fairfax County Police Department, the Commonwealth Attorney's Office, and all that helped, and we are grateful for justice. So our family has remained silent since the devastating loss out of grief, but also out of respect for the justice system. For us, Joe did not just die on February 23rd,
Yeah, and imagine how heartbreaking, again, because the media is going to take this and they're vultures and they don't want your story to honor and to respect. No, they see the salacious part of this. They see, oh, well, we can get clicks if we write, what he was into and what he was doing and reduce him to some character. And let's be real, these two women look like a hoot and a half. I would totally go have bottomless margaritas with them. I mean, she's a whole lot perky, but I'll let her go because she's so sweet. And the other one looks like she would be a blast. Look, her decor is my jam, okay? Except for that itchy, look, you can keep all the lace blouses. I will let you have them.
3, he was murdered over and over again. Every time lies were spoken, every time his picture was posted alongside salacious stories told by 2 wolves in sheep's clothing who perpetrated this crime and attempted to destroy the memory of 2 remarkable people. Julia and her boss/lover intended to snuff out the life of 2 innocent victims who deserve to live full and meaningful lives of their own. Well, while we acknowledge the defendant for eventually coming forward with the truth, telling the truth doesn't absolve her of responsibility. Honesty is something we're taught at a young age. Telling the truth doesn't erase the harm. It simply allows others to move forward. It doesn't bring Joe back, and it sure doesn't bring Christine back. Hearing the truth has finally allowed us to exhale. It validated to the world what we already knew, that Joe was not the monster he was portrayed to be. Rather, Joe is an elder brother, a brand new uncle, the eldest cousin and confidant to 4. He is my beloved nephew and a son and grandson to his loving family. Pardon me 1 second.
Oh, damn it. Damn it. But yeah, again, you guys, because when this first broke, he was labeled an intruder, someone who was deviant. What Paul, or not Paul, damn it. I was like, wrong bad guy. Banfield and this chick, we're all like, we saved the day. So they've had to live with the fact that everyone, and people that aren't informed may always think that he had something to do with this. Not that he was innocent, not that he thought that this was a thing. Yeah, so, I mean, I can't imagine the heartbreak of having to be quiet, let the investigation go, knowing that your family member wouldn't do this and having to wait for the evidence to speak for itself.
We acknowledge that Juliana was a young woman in a foreign country, in love with her employer in a situation where the power imbalance was not in her favor. But where our compassion ends is with the one other responsibility. Juliana was entrusted with and received payment for the care and protection of a small, innocent child. And Juliana, I feel, failed Valerie repeatedly. She was trusted to protect this young charge, but instead chose to cause irreparable damage. She robbed her of her mother. She stole childhood memories. She chose to partner in the brutal assassination of her mother's character, as well as her beauty.
And honestly, think how how unique a person to not only in your pain, in your grief, which as people have said, as I have said, can be overwhelming to the point of not wanting to get out of bed, that she can acknowledge that there was another victim and that not only, she might not be charged with the help of that, but she is just as culpable. And uh, it takes a rare person to be able to see outside their pain when they're walking through it and help and not only take their first chance to talk about their own victim, but the other victim. Very classy, very, very respectful, and she is so right. They stole from the child. I will never understand hating your ex more than enough that you wanna destroy your child by taking whoever away from them.
Beautiful being. The defendant and her boss/boyfriend convinced Valerie that a stranger broke into her home and killed her mother when in fact the monsters were the very people who cared for her after the loss. Julie and her boss worked to erase her mother's existence and credibility and place the blame on an innocent man. Our hearts go out to all of Christine and Valerie's family. What an absolutely incredible person she must have been. But may I tell you about Joe? Joe is loved. Joe came to live with the Ryan family. I'm sorry. I'm so sorry.
Oh, no, you're fine.
Joe came to live with the Ryan family just days after his birth. His birth parents, Dad, Sean, and Deirdre, who you met, were teenagers, so Joe lived with and was raised by his paternal grandparents, Connie and Jim, for all of his life. As a young child, Joe, who we call Joey, was fun-loving and loved from the beginning. He was inquisitive.
That explains so much because I got more of a friend relationship with the mom, and that really explains that, and then this woman was like his mom. And they never realized that there's so many more ripples of destruction. It's just I don't like it so much. Don't be an asshole, don't kill people. I It's that simple. If you're really mad at someone, sign them up for the Jehovah's Witnesses. I mean, allegedly in Minecraft. And have a wonderful day, Heather May.
Curious, smart, charming, and so dang talkative. Joe approached strangers and passerbyers with random and nerdy questions about Transformers and movie characters and the Legend of Zelda video game characters and who would win in a battle between this person and this person, and he respectfully waited the answers, whether you knew them or not. As he grew into adulthood, Joe's hobbies included building or painting anything that used his fine motor skills. He loved martial arts. He had a great love and respect for our environment, animals, especially mistreated, neglected, and ugly dogs. And he rescued many injured and less loved dogs, bringing them across the country in his travels safely home to the home he shared with his grandmother. Joe cared for people. He cared for animals, and Joe didn't hurt people. When Joe's grandfather, Pap, required care due to a debilitating stroke, Joe left his life in Virginia and moved to Florida to serve as the full-time caregiver to his grandfather,
Yeah, and I think there is this okay, so I am not gonna lie to y'all. I don't have a club, but I like spicy romance novels. And what I can tell you the appeal is most of the time now, granted, romance novels are written by women who then take the role of a man, so we are setting ourselves up for failure. But the selling point of an idea of a dominant partner is not someone who subjugates and controls you for humiliation or domination. It's more out of care. So, and again, you'll find this in even vanilla relationships. Like if your partner is the type that will stand up all day and, not take a break, or like Mr. Mo, he'll have to bring me in food. That would be part of a more dominant, subservient relationship, depending on the parameters. You have one who's really, a caretaker, more dominant. It's implicit in there that you care about the other person. I mean, basically all of it is about care. It's just some people like weird things. Oh, I have not had enough of my fun soda yet for that class. Yeah, and look, just because I don't get it doesn't mean you don't get it. Look, like I said, in Mo's commune of introverts, we will have a don't ask, don't tell. I don't care what you do, just don't make it your personality. That's all I ask.
Supported him from infancy. When Pat developed dementia and had to move into a memory care facility, then Joe moved back to Virginia, where he began to take care of his grandmother, who had begun to experience health problems of her own. Joe took over transportation for medical appointments, hospital procedures, food shopping, and the bond between Connie and her grandson was as close as that of a mother and child. Joe would never have put himself in a dangerous situation that would risk his ability to continue to take care of his beloved grandmother or his old ugly dog, Kitty. I'm sorry, she's not ugly. When Joe didn't come home, Joe's grandmother, Connie, lost the gentleman that she and Pat raised as their fourth son. Joe's sudden murder devastated his grandma, who was 81, and devastated her so much she could no longer live in the family home without Joe, and quietly and quickly sold her home to dodge memories, grief, and reporters to move closer to my husband and me. My husband is Joe's Uncle Jimmy, and I'm his Aunt Gita. In Joe's absence, my husband and I made the decision to leave our careers and to take over his grandma's support and care team. We continue to do that today, and we think about and talk about Joe every single day. Honorable Judge Asgarati, we feel Joe and Christine were targeted by the worst kind of monsters, the kind who live among the victims and wait until they're the most vulnerable. We feel as a woman, a caretaker, and as a daughter, Juliana had opportunity to stop this brutal assassination. We think she could have warned Christine. We think she could have warned Joe that morning. This could have been a very different ending where Juliana saved 2 lives. But that's not. At least she should have done the job for which she was being paid, to protect a child. She did not. So many opportunities to do the right thing, and Juliana over and over chose not to. And while we acknowledge that she found the strength to tell the truth, it doesn't absolve the responsibility. So today we leave here finally standing as Joe's family. This nightmare's ending. It's our hope that Juliana doesn't walk free, but continues to reflect on how she became capable of doing this, so that when she does return to Brazil, she never victimizes another person, never betrays another child in her care, and never again places selfish desire above human life. She doesn't deserve to profit. We hope that can be enforced. The reality is, though, she will be free one day, and our hope is that she carries the weight of the lives destroyed, that Juliana chooses to live as a decent person, and that she is truly remorseful. The sentence that Juliana receives today is not the only one given. We all carry a life sentence of grief, even after hers ends. We ask for peace. We ask to be allowed to move forward. Today we move forward by returning Joe's kindness to the world. We say his name proudly. We invite the world to finally know the man we protected in silence for so long. He is loved. We miss Joe, and our family is devastated by the way he was ripped from our lives. Joe won't complete painting his unfinished Warhammer 3D figurines. He won't compete in any more live-action role-playing battles with silly, hand-created foam weapons, nor his mixed martial arts or video game battles. He'll no longer bore us with lectures about eating organic food over junk food, but it's with our hearts we thank you, Honorable Judge and the jury that was here, members of the court, the police, the detective, the prosecution team, the victims team, and all the witnesses who supported justice for Joe. Thank you so much for listening.
Please answer any questions that Mr. Campbell might have.
Any cross-examination?
No questions, Your Honor.
All right, no questions. All right, you can.
Thank
go
you
back
so
to your seat.
much.
Thank you, Ms. Ryan.
Judge, I don't have any further evidence, but I do want to acknowledge to the court that the family of Christine Banfield is here today. You can see them to your honor's right,
All right. Thank you. Thank you,
along
ma'am.
with Joe's family.
All
Thank you.
right, thank you. All right, Commonwealth's rest for evidence. For the defense residents, I do have for your evidence the memorandum of support of sentencing, which I
Thank
have
you, Your
reviewed. In addition, 3 letters that you have provided
Yes, Your
as
Honor.
well. I reviewed those as well.
Your Honor, I'm going to hand up a few certificates that,
Sure.
Mr. President, they can just be made part of the record there.
Okay. Are
And
these
no
okay
further
to be,
evidence.
can be part of the file, or do you need copies? We can make copies of them if you'd like.
That'd be fine, Your Honor.
Okay,
Thank
we'll
you.
make copies. All right, let me just review them, please. All right, we'll go ahead and make copies of these certificates and make them part of the record as well. All right, any other evidence from the defense?
No further evidence, Your
All right, argument?
Judge, the Commonwealth in this case, as the court is aware, made a recommendation, and the Commonwealth stands by that recommendation.
All right, argument, Mr.
Honor.
Campbell?
Thank you, Your Honor. Your Honor, the 2 witnesses that you heard from today made it clear that hearing the truth was valuable to them, to the Ryan family, and it was the truth that Juliana spoke at trial. And ultimately, it was her testimony that likely resulted in the conviction of Brendan Banfield. Until her cooperation, the Commonwealth had only a theory. They had circumstantial evidence, but no direct evidence. When Juliana finally came forward, she offered that direct evidence of what crimes she'd been involved in and what crimes were committed by Brendan Banfield. Your Honor, our position is that justice requires that the court follow the joint recommendation of the parties. Justice requires it because it was an arm's length agreement made by an experienced prosecution team with the approval of the head of the office, with the knowledge of all the facts and circumstances of the case, not just the facts of the case, but issues that would be presented at trial, with presentation of evidence and witnesses, sentencing guidelines, and many other factors that the parties consider beyond what the court might realize. Justice requires it because Joseph Ryan and Christine Banfield and their families deserve justice. By accepting responsibility in this case and cooperating, we avoided 2 trials. We avoided.
Okay, accepting responsibility, cooperating, and then there is an atonement. You do realize this is a 3-step process. We don't stop at, I'm sorry. No, there has to be a show. This is why, Hercules had to do the 12 trials and the labors of Hercules, because he had effed up. This is why Solomon was turned into a donkey. This is why, a lot of things happened because, atonement, you actually do have to show that you have taken your big F up. You have looked around at the hurt that you have caused. You have honestly, and that's what I was going to say. I was like, what the hell, what in the Stranger Things is going on here? Or the Samwise things is going on here?
We assured the finality of the decision in this case, and we gave the jury and the Commonwealth and the court confidence that Brendan Banfield would be convicted, as he ultimately was. Justice requires following the agreement because every individual that makes
Following the recommendation.
Recommendation, yes,
Thank
Your Honor.
you.
And I addressed that in my memo, of course. Every individual that makes a difficult decision to cooperate does so with the belief that the recommendation would be followed or at least considered by the court. The Commonwealth, the courts, and prosecutors in courts everywhere in the country rely on cooperating witnesses to do what Juliana has done in this case, which is to speak to the truth and offer direct evidence of crimes, including those cooperating witnesses that they themselves have committed serious offenses. When a prosecutor makes a promise, the court ought to give it serious weight. Your Honor, I'll say I'm disappointed but not surprised that the Commonwealth didn't advocate today for the recommendation. I have deep respect for Ms. Bristler and Ms. Sands and the prosecution team. I suspect that this is frankly because of public sentiment regarding the agreement that they made.
Maybe.
Recommendation.
Recommendation. I'm going to continue to make
I
that mistake.
understand.
Your Honor, I just want to touch on a few things that I've just reviewed.
Yes, yes.
Your Honor, the importance of the cooperation. Ms. Sands did communicate to me that she interviewed the foreman of the jury, who said three things to them, three things that Ms. Sands relayed to me, that they believed Juliana Perez Magalhães, that her testimony was integral. That was the word that Ms. Sands used. In other words, central to their decision to convict Brendan Banfield. And third, that they didn't believe Brendan Banfield. Your Honor, that is important for the court to consider because, again, up until her testimony, which was presented first in the Commonwealth series of witnesses, the Commonwealth had only a theory. The Commonwealth had circumstantial evidence, forensic evidence, electronic forensic evidence, digital forensic evidence, and others. But it was Juliana who ultimately told the story firsthand of what occurred. Because that decision was integral in the jury's decision, I think it could be said, and of course the court presided over the entire trial, you can determine her credibility yourself, but the jury certainly found it integral to their decision. And for that reason, the Commonwealth's recommendation, the joint recommendation, should be given heavy consideration by the court in this case. Your Honor, I briefly want to just touch on the delay in cooperating. It was evident to the defense that from Juliana's first date of arrest that they wanted her cooperation desperately. Her cooperation didn't come quickly. And our position is that at that time, she was still under the grip of Brendan Banfield, and the plan that he had convinced her would work. She still believed that there wouldn't be sufficient evidence for a conviction, and she was relying on Brendan's plan to get her through her arrest and prosecution. As she languished in jail, discovery dripped in. We really didn't receive significant discovery until after the preliminary hearing in this case. And even leading up to the trial date, we still hadn't received much of the digital forensic evidence that was.
Hey, maybe after you've pled is not the time to whine about how and why you're not a good enough lawyer to have crafted a better plea deal. Like, we didn't get discovery, and it was like a hard thing, and I was sad. And she helped. Like, didn't you see? It's not shake and bake, for the love of.
Was made central to Brendan Banfield's case. Your Honor, the tipping point was perhaps the arrest of Brendan Banfield. That broke his grip on Juliana. The communications between Brendan and Juliana ceased. There were no further assurances that things would be okay for her, that they would have a life together afterwards. She was left alone, truly alone. No communications from his mother or family or other people, and no ability for her to actually contact her own family. She was left alone upon Brendan.
She killed someone. I kind of find I don't give a rat's ass if she was a little lonely. I am so lonely, so lonely. Why does my brain always go to Team America World Police? Kim Jong, he had a good voice.
Arrest, and that was a huge factor in her coming forward. Your Honor, when she did come forward, we moved rapidly. We had a lengthy debrief followed by a plea within a day or two of that debrief. The next several months resulted in continued debriefings. We were available at every request of the.
What in the, Ramirez Night Stalker is this chick's look? Look, FBI, I'm not telling you how to do your job, but if I was using like maybe a not federally sanctioned, facial recognition, pre-crime, AI, this heifer's face would be on it, okay? Allegedly in Minecraft. Don't you avert them demon eyes away from me.
The Commonwealth. She continued to be candid and open with her statements, and I haven't heard any issues with her reluctance to answer questions in those debrief sessions. Your Honor, if she hadn't testified, there's a good chance that Brendan wouldn't have been convicted. First, the Commonwealth believed her. Secondly, Brendan chose to testify himself. I doubt he would have done that without her testimony. He chose to directly challenge her statement of offense of her account of what occurred, and he was caught in his own lies. Beginning with shortly after cross-examination, the question of whether he loved her or not, and him saying, well, I didn't really love her. There were certain things that were in the way. And finally ending with his testimony about an important meeting that he was going
Like her
to.
eyebrows?
Upon reviewing that testimony, his boss came forward and testified the next day that there was no meeting. Brendan's lies ultimately resulted in his conviction, but he might not have testified if Juliana hadn't been testified. Your Honor, I appreciate the comments of Joseph Ryan's family, and I've read the letters that were filed by Christine's family, and there's no words I can offer to console them at this time. But it is critical that there was no trial in this case, that there is finality for the families, and that there was cooperation by Juliana that resulted in Brendan's conviction. Your Honor, the last thing I want to comment on is the agreement in this case, the recommendation.
Thank you.
I had hoped the language of the plea agreement says that the Commonwealth recommends. It doesn't say they have to get up and advocate or pound their fist and argue to what extent the cooperation was important. But the court can weigh that yourself. It was critical. Her cooperation and testimony was critical to the outcome of Brendan Banfield's case. This was an agreement for a recommendation that was made with full knowledge of what the facts were of the case and what public sentiment might be regarding the agreement for Juliana in this case. The agreement was made anyway.
Recommendation.
Thank
you.
The recommendation was made with the input of all the victims, of the police department, and all the important people as required by law. And there was no pushback at that time, Your Honor. I have a position in my sentencing memo whether this is an agreement or a recommendation under A1, A, or C. I'll maintain that argument, Your Honor. I ask that the court follow the joint recommendation of the parties and impose an active sentence of no more than time served in this case.
All right, thank you, Mr. Campbell. All right, Ms. Perez-Maglese, if you could stand up, please. If you could stand up, Ms. Perez-Maglese. Is there anything you wish to say at this time before sentence is imposed?
Yeah, I would like to read a statement. I have caused your pain that cannot be measured and forever changed so many lives. I pray for forgiveness from the Benson family and from Joseph Ryan family and from Valerie. I will never forgive myself for the pain caused. I hope that my cooperation in this case somehow begin to help repair the damage caused. There is nothing I could possibly do to make it up to you, to your loss. Sorry. There are so many regrets, but this is my biggest. That's a tragedy I have been carrying with me, and I will always do. It's something I have nightmares with. A tragedy I know I can never take back the devastation of what I have done. I know that my remorse cannot bring you peace. I hope you might.
No, I kind of want to hear more about your nightmares, though. Are they really bad? Do they scare you? Tell me about them in detail. I want you to relive them just a little more. Oh, you carry guilt? Oh, well, they carry grief. I wonder who I care more about.
Someday understand that I truly did not believe that his plan would have actually happened. I have grown so much over the past 3 years. And look back at my younger self at 22 years old.
Screw you, ma'am. You know what? At 22 years old, you know what I had? I had one child. And I was, well, because apparently birth control is not a thing that works on me, I was pregnant with my second child. I was an adult. I was going back to school. I was working full time. So miss me with the I was a child. No, no, you are a child until you are 18. I don't know who needs to hear this in 2026, but you are a child until 18. Now you can be considered a kidult until your late 30s, given maturity levels here lately. But I swear to goodness, this I was only 21, I was only 22. No, you are not a child. You are just a dumb adult.
Falling head over heels for someone 15 years older. They only see his good side and clinging to someone that showed me love.
We've got
I lost my.
Sorry, we've got a door opening and so I'm wondering if we have another question. I am looking at X. If anyone is a better Xer than me, or Twitter, or whatever the hell we want to call it, and you're on Lawn Crime, I'm trying to keep up with it. The verdict clock is still going, so maybe he's going to send them on lunch break. Because some localities just let them deliberate through lunch, and then some tell them to go to lunch and don't deliberate, which I think is stupid. But I don't run everything in America, which is why things are not efficient. Yeah. Yep. And I do wonder, I think they can go until whenever o'clock. So I do wonder, you know, what they're having an issue with, because I think it was interesting that they wanted to see those 2 particular times. And honestly, no single piece of evidence pro no single piece of evidence except for the pants. I mean, honest to God, for me, the state could have stopped at the red rum weapons and the pants, and I was like, "Nope, he's guilty." That and the, garage camera. So, I guess I'm having a hard time wondering why they were wanting to look at those 2 particular videos. Now, maybe there's another question? Because I am trying to figure out why we are wandering in and out. Watch it just be him using the restroom, and we got punked. Could be, but generally they stop the verdict clock. Let me, we can look at chart, or let's see. He's a tease, LOL, lunchtime, maybe. Does the judge announce lunch or something or other? Uh, but why? Da 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 da. I'm thinking there's so much evidence that they're meticulously going every do. All right, I will keep an eye on it, and we will go back to her. Don't you feel sorry for me? I accepted responsibility. Yes, that is sarcasm. Yes, I do not feel sorry for this woman. Sue me.
Myself in a relationship, leaving my morals and values behind, and putting even my loved ones through this. My time in jail has been a time of reflection for me to better myself in more ways than I realized I needed. I had to find myself again. That's when I truly found God, when I had lost the desire to live.
Okay, I know I might be a slightly autistic asshole, but I swear to God, how do you lose yourself? Mother effer, you're with yourself all the goddamn time. I have never understood this. I maybe I'm the most emotionally constipated woman there has ever been, but it literally confuses the hell out of me. Oh, we've got movement again. Sorry. I love that the ADHD is with us all today. And StreamYard, could you keep the chat going with I like pulling up y'all's chats in order, but swear to daggone giblets, it is having all the issues keeping up. Well, Jesus does live in apparently solitary confinement. I always thought it was funny. People used to say I found Jesus, and I was like, behind the couch or in Where's Waldo? I love that we're all like, movement, no movement, movement. He's coming. No. The judge has ADHD. Confirmed. Every time I think, keep getting punked. I know. Well, again, I will, until he sits down with his robe thing, we will not be punked again. We shall listen to Don't You Feel Sorry for Me.
When I wanted to die, the guilt and feelings that
Again, I don't feel sorry for you, and that makes me maybe a callous person, that makes me a callow person, but I don't care. I really hate when these statements turn into, "Don't you feel sorry for me? I'm gonna have some guilt." Like, mother effer, you should.
I didn't deserve to live and that I was a monster were overwhelming. In God, I found the forgiveness and mercy, and I am restored. Jail is not a place you can bear to let yourself drown in those feelings. I wanted to disconnect from my pain and the guilt and get into survival mode to stay mentally sane, because inevitably, with memories come pain. Yet, I know I will live with this for the rest of my life. God and I only know the shame and guilt and sorrow I carry for all I have caused. Sorry for Joe's family and Christine's family. Sorry for Valerie and innocent little girl who has so much love that will grow without her mother and our father. This is a heavy burden to carry, knowing you could have prevented it all from happening. I understand that I am to blame, and I'm truly sorry for the pain it caused. I hope someday I can be forgiven, as I hope to be able to forgive myself. Thank you for the opportunity.
No. See, oh my God. Okay, here, moron, because I know you probably are part of the My Truth Brigade. Let me explain it to you. You, have to acknowledge that you were an asshole. You, then apologize and realize that just because you apologized doesn't mean that you should expect to A, ever be given the same level of trust, or B, ever be friendly with this person. This person is not required to ever talk to you again, depending on the level of fuck up. They're just not. Now, if they choose to, understand that you are going to have to prove yourself more than you've ever proved yourself. And if they question you, they have a right to question you. You screwed up. Now, if they continue to question you after you have proved yourself, you know, after a length of time, okay. You forgive yourself then, because guilt can mire you. It can make you, you know, go into the same pattern that, giving yourself all of, you know, the same kind of selfish behavior that, caused you to unalive someone. Guilt can cause the same kind of reckless, stupid behavior that could hurt someone. So how about you pull your head out of your ass, be an adult, put on your big girl panties, figure out what the hell it is that in you. Yeah, she got a plea deal. I don't quite remember. The judge keeps going in and out, so I'm trying to watch that.
To speak. All right, thank you, ma'am. All right. In this matter, the court does find that the manslaughter charge was the large benefit of your bargain for testifying, which was a huge bargain and a plea deal. You could have been facing life plus 3 years, and now the maximum I can sentence you to today is 10 years. That's clearly a trade for your cooperation with the Commonwealth and what the Commonwealth offered. And you accepted that along with the Commonwealth's recommendation for time served, which is not an agreement, and as you know, not binding on the court, as we discussed at length at your
MLS, kind of odd for us. We are watching the sentencing in the au pair part of the Banfield trial. Now, she did have a plea suggestion, basically not a deal, but a recommendation. So, yeah, believe me.
plea. The reduction of the charge is a mitigation. I have watched your interviews and I watched you testify, and I just cannot find any further mitigation factors for your case.
Oh, this judge is nice, because I swear I would add 15 years for every time you use your sleeve as a Kleenex. I've had 6 children. I can deal with a lot of things, but the snot rag sleeve is just that, and this thing right here, the favorite thing of children, young boy children, just nope.
You may not have come up with a plan, agreed, and an older man may have groomed you to a point, but I want to list for the record the facts that I cannot equate with accepting a time served recommendation. These are aggravating factors either not fully captured or not reflected in the sentencing guidelines. Number one, until today, you have shown no empathy for the victim in this case. Number two, you were more involved with the plan than you testified to. First off, there were numerous postings on social media platforms and text platforms looking for a target, texting and speaking directly with Joseph Ryan, encouraging him to bring the knife, and ultimately through the phone conversation, getting his consent, knowing all along you were bringing him to his death. Lying to Christine and setting up the plan for the zoo, using her devices and hiding her phone, using a child as a pawn in your plan, waiting outside for Joseph to show up, calling Mr. Banfield to bring him to the scene, and at any point for at least the month prior or that day, you could have stopped this. The plan did not work without your full involvement. Number three, having the loaded firearm in your pocket. Number four, bringing a child into the basement knowing 2 people were about to be murdered, to include the child's mother. Number five, hearing Christine ask you to call 911, which you did and then immediately hung up. Number six, seeing Joseph Bryan, who was shot in the head at that time, still moving and walking up to him as he lay moaning on the floor and shooting him point blank in the heart. Number seven, watching as Mr. Banfield stabbed Christine over and over again. Number eight, waiting 15 minutes before recalling 911. Number nine, telling a fabricated story for over 1.5 years, a story that depicted Joseph Ryan wrongly as a rapist and a murderer, an innocent man. And number 10, telling the child it was okay to call you mommy hours after the murder.
What the ratchet swamp donkey fuck? Holy hell no. Oh, hell no. Allegedly in Minecraft, tiny baby Jesus, if Gen Pop justice should fall upon this woman, allegedly in Minecraft again, my tears and cup of sorrow shall be dry as a bone.
Your actions were deliberate, self-serving, and demonstrated a profound disregard for human life. So let's get it straight. You do not deserve anything other than incarceration and a life of reflection on what you have done to the victim and this family.
Hell
May it weigh
yes.
heavily on your soul. So today I'm sentencing you on a manslaughter charge because that's what's before me. And the facts of this case demonstrate an intentional and calculated level of violence that is the most serious manslaughter scenario that's.
JKD Bug, so Swamp Donkey, when I call you garbage is when you really need to watch out. Because if I still think you're redeemable, I will call you Swamp Donkey, Mega Thunder Cunt, all the sort of things. That being said, when I'm done with you, like after this, I never want to see Paul Caneiro. When he is adjudicated, he is human filth. Yeah, pretty much. If I call you human garbage, you are no longer redeemable. Like, as I have often said, I hope Jesus loves you because everyone else thinks you're a cunt. So if I call you garbage, like you're on your own. I could see you on the side of the road and I'd be like, so long, baby weird fetus Voldemort, at the end of Harry Potter. I'm out.
This court has ever seen. Therefore, I do sentence you to 10 years in the penitentiary, as required by Virginia Code 19.2, 295.2. After you've completed your 10-year sentence, I will order an additional 2 years suspended, and you will be placed on probation pursuant to Virginia Code 19.2, 303. Since you have been convicted of a felony in Virginia, a sample of your DNA will also be drawn from the state police database. Are there any questions, Mr. Campbell? All right, anything further in this case? No, ma'am. Okay. All right, you're mandated to the custody of the sheriff. I believe that completes the docket. Is that correct? I believe so. Okay. Court will be in recess. All rise. Court's in recess.
I will have to look that up. I don't know the particular statutes in Virginia as far as good behavior and what she's entitled to as far as, let's see, good behavior, days served, and things like that. Now, the judge going in and out all that time and the verdict clock being paused is because the jury is going on lunch. So we will probably go another 30 minutes on this stream, take a 30-minute break, and then come back for the afternoon session of watching Verdict Watch. Now, knowing my luck, as soon as I get the other stream set up and go to take a bio break, that's when they'll come back with a verdict. But we'll cross our fingers.
Who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019, she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point, but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record's clear, I also want to note the text message that she sent to Jennifer The state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using.
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not.
You know what I wish people would understand? Where in the hell am I getting video from? Oh, that's what we're doing. They decided to change the verdict watch since it was on lunch break for court TV because of course I'm OCD, so I have court TV and law and crime up on my side screen, and they decided court TV decided to go to something different for for that. She's so petulant. Again, just admit that there might be a possibility that you could possibly be wrong about something. It's not a character flaw. What is a character flaw is when there is wisdom or you are unable to accept the fact that someone might be smarter than you. Someone might know a little bit more than you. I know it is hard to comprehend, but it might actually happen that once in a while, you know, you're not the smartest person in the room. What is going on here? I just need to make a thumbnail for the next stream. Thank you so much. I love that I yell at it. Now, I do think that there is a slight possibility that we do end up going into next week, despite it being being fairly obvious where all the evidence is leading. I do feel like this is an incredibly important case. Not only are these jurors, as much as we'd like them to, you know, go fastlier. And again, here, a perfect example. Okay, knowledge is understanding that fastlier isn't a word. Wisdom is knowing that someone who intentionally used the word fastlier probably doesn't give a fuck if you tell them that or try to correct them. I'm just saying, not that I haven't been the bane of every single grammar and spelling, you know, enthusiast my entire life. I do my bestest work hurting people that like to spell. So there is a real difference between, you know, knowledge, which is, you know, a factoid. Wisdom is knowing when to bring up that factoid, when to use it, when to actually bring that knowledge in the nebula of knowledge that you have, which is again being so much more generous to her than I really, you know, ever truly am most of the time. I'm being so generous to her by even assuming she has an internal logic by which she operates. Facts not in evidence, really. Doo-doo. Yes, I have done it. So we will probably go another little bit because then I want to take you through the character witnesses because I have never seen a defense so incredibly tone deaf with their character witnesses. It was really a walk through, there's something very wrong with every single one of you kind of lane.
100% accurate because the document that was 100% accurate to refresh her recollection would have been what you had in your possession, which was the screenshot, which included underneath the word red, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning.
I don't know why it tickles me so much that she footnoted herself. Of all the vain, egotistical, like, sometimes I think I have a huge ego because, I constantly question, how much time I spend on my stream or, you know, that was the big thing about the table. I was like, "Do I really need to spend more money right now on when I do have a desk, but it's just not comfortable?" So I always think I have a big ego because I'm like, "Ooh, if I won the lottery, I would totally buy some Sailor Moon stuff." Like, I'd put a little portion aside to buy, whatever the hell I wanted and not give an F, like all of the Lord of the Ring Legos, every single one of them, and the light kits, and the covers so my cats don't destroy them, every single one, and then a biometric lock. But after that, like, everything else would go into a family pot. I don't care. I don't know where I was going with that. Let's continue.
So I guess this is during a conversation that you had with her that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court.
There was this other trial in history where, I was just following orders, didn't really work either. But let's see how it works for her. It's a bold strategy, but I'm just the messenger, not what you would call like the legal guy in the case, the legal talking guy.
Is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true.
Oh, yeah, I love this. Like, the court is using things like mean and deliberate. Like, how dare the court imply my intentions because you are. Look, we either accept. Would you like us to accept malice or stupidity? I can either accept this as complete incompetence or at this point, malice. So which would you like? Stupid or awful?
I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's.
Because, ma'am, you are arguing that like I took a screenshot, which again cannot be authenticated by anything. Where did you get the screenshot? Where do we have the megabytes or metadata and the hashtag and the gray key and the celebrate of stupid that would say that particular thing that she looked at is absolutely, totally, completely and, positively, completely and utterly freaking, correct. No, you just have a very interested witness who is the daughter of the defendant coming in and telling you the day before she's going to testify in a trial that's been 7 years in the making that she, oh, by the way, had this really important information she learned about, 6 years ago, but never told no one. Yeah, I can't imagine why the judge is upset about this evidence trying to slide in.
True. I'm using it because it's true, Miss Maslone. So don't say that I'm using these words for any other reason because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is you can roll your eyes for the record as you just did, but the reality.
Again, I say, hell, this is why. Now, I'm going to tell you, y'all, This woman was obviously not a latchkey child. This woman was a product of gentle effing parenting, because let my mom have caught me rolling my eyes at her. Like, first of all, I'd be, what is it? Sandy Duncan, like I'd have had a glass eye because she'd have snatched my eye from me. Second of all, I'd still be in the intensive care unit, okay, in a coma. And when my mom would tell the story to other people, other 90s moms would be like, it wouldn't be like, "Oh my gosh, did you think about that child's feelings?" No, hell no. They've been like, "Yep, I had a kid that had 2 eyes too. I understand." See, so you millennials, you genlennials, you children of the middle and late 90s when parents started getting all gentle and crap, y'all don't know. Y'all do not know. Like, we did things one time. One time. Now, this woman has obviously not been told no, because again, this isn't about how you're feeling. You are upset because they're true. He is telling the truth. I don't know, where did she go to school? How is she unable to not argue? I mean, of all the things that I disagree with Kurt about, this woman is arguing about emotions. And no one gives a crap about your emotions. You're a terrible lawyer who couldn't figure out a way to put this in other than lying and sneaking around. Own it. Don't be a petulant child. Because Judge Kent has been so much more patient than Judge Moe would be. Judge Moe would have made Tristan Esquire Ponytail the third fucking cry day 2. I'd have been like, "Look, yoga man, I'm gonna eat bacon right in front of you." Just come in every day with a big old bacon sandwich, which, thank you, UK. I didn't know that we needed this, but I've always argued that the best part of the BLT was the bread and the bacon. And you guys knew that there was a need, and you saw it, and you answered. I'm impressed.
Is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me.
Again, also, here's the other thing. Take ownership. You know what people actually respect more than, you fighting on a dead hill with dragging a dead horse? Hey, you know what? I thought about it, and I didn't go about this the right way. I apologize, and, you're right. I was thinking about it in maybe a different way, and I appreciate your perspective. Instead of like, well, I guess whatever you say. And welcome, Broken Baker Raiders. We are watching some of the weirdest moments in the defense case. We are going to be on for another about 15 minutes, and then you guys will be ported over to the afternoon stream that starts at, oh Lord, when did I start the stream? I love that I'm smart. 2:30. So we will be back at 2:30. There has been one jury question. I do have both Law and Crime and Court TV going. Now, the verdict clock has been shut off, but they are on lunch. And Miss Scarlett, we are watching her get roasted, basically. So I'm having fun because she really is insufferable. I have never seen a less prepared, more insane defense.
If there's anything that I can say to further my position that
this is not HR. Again, I'm going to go back because no one gives a rat's ass what you feel and interpret judge as feeling because the judge is, bringing out facts like you failed to do discovery right.
Everyone, I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So
I have never, and y'all, we have watched B. Ivory Lamar. We have watched Daryl Brooks. We have watched, well, God, Sarah Boone. We have watched, what's the other one? We have watched pro se defendants do better than this defense attorney, who in theory is a public defender and a deputy, district deputy public defender.
don't say that I'm using these words for any other reason because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that.
Oh, okay. Women, ladies. Look, I totally admit that I am a fan of logic that usually precludes me from being in the girl secret meetings because I don't give a shit about Taylor Swift or most anything girl related. So, but could we possibly, and I do mean possibly. Got to go back 1 second. Could we possibly stop this? Look, male, female, I don't care who you are, but if you do this passive aggressive, algebra of human relationships, I'm sorry that you feel that way. Fuck you. I would rather you say, I would rather you say go suck a donkey dick than I'm sorry that you feel that way, because that's essentially what you're telling me. And I would rather you be honest, and I would rather that I can say, well, fuck you right back too. I mean, could we just be honest? Because that seems like a much more, I don't know, clear communication thing. I mean, yeah, maybe it's not kosher, maybe it's not, with the nicest words, but at least we're honest, and at least you don't think that you're actually doing something noble or virtuous, and I don't have to pretend that I give a shit what you think. I mean, this is why I don't work in an office, as you can tell.
It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times.
Because you have a tenuous grasp on what we like to call common sense in the law, bitch. Felicia, see me later with this. Everyone is mean to me, like the judge was judging me. Bitch, it's in the name. It's called judge. I don't know. This isn't church. This isn't a commune. You are literally in a place where it's like courtroom, judge, jury. It's almost like you're in the perfect place where you would expect to be judged. It seems like you have a bigger problem with being found unworthy. I just wish you would address the problem correctly. So maybe I am on the autism spectrum, because this bullshit exhausts the hell out of me. I would rather her just, again, if I'm the judge, instead of like, I guess you're feeling like all sorts of feelings, I would rather her double deuces me, because at least that's honest. It's honest. I know she doesn't respect me. This kind of shit, this subtle disrespect, I need a taser. Also, I'm guessing I'm not gonna get hired at any offices ever again, which I think is healthy for on both sides of that relationship.
Times to make sure that it's okay to ask certain questions, as I did before Katie Caneiro's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There was a 25-page ex parte letter that pertains to Corey Caneiro, the court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that did seem to me to have the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post behavior by Corey and or his wife or ex?
It's also, again, it's this continued kidult behavior. A kidult, a young 20-year-old would cut off their nose to spite their face. She wants to be right. She wants the judge to tell her she was so clever to find this loophole where she skirt, if not ethically curved or broke the discovery rules. She thought she was so clever, and he's not acknowledging her awesomeness. No, no, he's pointing out that what you did was ethically wrong. That, yeah, it's not, a sanctionable thing, but it only takes that first time where you cross that line into a gray area, and it becomes easier to go further and further. So you need to stop that. So she is willing to fight and raise her voice and possibly get held in contempt of court, even though it is going to probably not be so great when her defendant has to get sentenced. It's unprofessional. Adult. Yeah, no one likes being dressed down. No one likes to be told, "Hey, you kind of are a screw up today. You thought you were really clever. This thing that you thought you were gonna do at the last minute and have a Matlock moment, and you were so proud of yourself, was actually, something that was not good, and I'm gonna put it on the record, and people are gonna know about it. I'm gonna dress you down." And yeah, that sucks, but that's part of growing. And I would rather have someone dress me down because they think I'm capable of doing better. That's the other part of dressing you down. If he didn't think that she was capable of learning anything, he wouldn't dress her down, because what's the point? It's like trying to teach algebra to, a German shepherd. There's just no point. The fact that he thinks that you could, if you actually, maybe stowed your ego just a little bit, learn, is a sign of respect. He doesn't want you to F up, if only for the self-defense that he doesn't have to stop the trial every 5 minutes and have a confab with you to explain law to you. If we're the completely 120% selfish reason to, have his trials move easier when you're involved in them, it's still respecting the courtroom. Your attitude doesn't just disrespect yourself. It doesn't just disrespect the defendant. It disrespects our justice system. And yeah, it's flawed. And yeah, it's not the best thing all the time, but it's what we've got. So all of this is just irritating, especially after what we heard on Wednesday of last week when this happened. So after we heard the medical examiners, and I did try to warn the defense that their stupidity was going to hit a lot different after that testimony, and they did not heed the warning.
Wife, that I was not going to allow.
Really, a cat man? I would encourage you to watch it at 2 times speed if you're going to watch my streams. I believe the defense was 3.5 hours, and the state altogether was 3.5-ish as well. So it goes 2 days. So Godspeed.
some of this conduct to be brought out. Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, that's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020, a contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house and getting stuff out?
I mean, could you imagine her doing that to Borowski? Y'all, could you imagine Borowski and her? Like, she thinks like, your tone is like accusatory and meanerating, and I just don't like it. It's like all mean. And I was being really, really like, I was trying to listen to your truth, but my truth is more important because I'm a woman.
Judge, could I just...
It might have been a mix between Petrozello and Detective Vogt.
I think...
Y'all, if you are joining me from Broken Baker, this is the dumbass duo that we have had. Let me introduce you to Kim Kardashian and Tristan Esquire Ponytail III, the two dumbest attorneys ever created, ever.
Who specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no...
You know what I'm asking you. We're not talking about AIG. We're talking about the fact, what's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says
it? I mean, at this point in time, I don't specifically. I don't have a recollection of exactly where that came in the trial. Okay. I know I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure. I know it's a fact we knew, I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case. But number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not.
And again, if you're new here, we've called him Judge Kent from Real Genius. If you know, you know. He's not a fan of popcorn. God, I love it that JKD Buck and I watch obscure 80s movies ad nauseum. But he's actually been very, very good at keeping track of all. There are just binders full of evidence. There were 2 different crime scenes. There was 2 different arson investigations. There were 4 homicides. So there was a great deal of evidence in this case. And he's been very diligent. He's been very diligent about asking clarifying questions when the defense isn't very good. Trying to help ask questions for the defense, again, for witnesses to understand. So to pretend like something came in when it didn't really is just galling with the amount of attention to detail that he has paid to this trial. He has been a remarkably good judge. He really has been paying attention to the jury and noticing when they need a break. So I do like him.
Saying that I'm right. That's why I'm asking these questions, because I don't think it exists and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony. And I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible piece of information, I don't know. It was in the discovery and they don't have the iPad. So from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple of days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was irrelevant.
Okay, again, riddle me this, Batman, because I thought that lawyers were kind of inquisitive people, or at least people that like to be strategic in the way that, hey, if he has been lenient to a point, but this is the first time that she's shown him direct disrespect and direct kind of subverting rules. He's been very, very fair with them. I think he's called balls and strikes pretty well. But this is he's been very clear that certain things aren't going to come in, and the defense has been testing the line a lot this case.
In fact, to elicit, the state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a
confidential.
Sixth Amendment issue. It's electronically stored information. And it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutors, is there something you want to say before?
Judge, I just want to clarify something that really is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire.
No.
That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds at school. So that's just to close the record in that regard.
Again, I want you to imagine that you are using this as an argument in real life court, not like the people's court, not like, Judge Judy. You're going up against or up to an actual factual real life judge, and you are a lawyer, an officer of the court, and you don't research the fact that this information came from an 11-year-old, rumor mill at a middle school. Holy God. And there will be more like that. I am going to take a bit of a break. So I do have you guys set up to go to my afternoon stream. They are still on lunch break. So we will be back at 2:30. I am going to take a quick break, use the restroom, get some lunch, all those fun things. Do have an emotional support snack because we will be going through the defense's greatest hits, their case in chief, and the cavalcade of weirdos that they have decided to bring on to say that Paul Caneiro was a great man is, y'all, you have not seen such sideshow interesting people outside of a state fair in years. So buckle up, you guys. I will say, I do think that there is a very light possibility that we might be going until next Tuesday. Do remember that courts are going to be closed on Monday, so we will probably be catching up on our reverse speed run of the Banfield case on Monday, so that's what we'll probably be doing. But we might be waiting for a verdict on Tuesday. If we are, we'll just be waiting. So I hope you pick the Petty Express to hang out with, and I will see you all at 2:30. Bye, you guys.